All right, let's bring her in. This is episode number 440. You know her as one of the judges on the syndicated court TV show Hot Bench. She is a multi-time guest on the show. We haven't had her on since that wonderful, very eloquent, very easygoing back and forth with David Gingras. It is Rachel Juarez. Rachel, thanks for coming on.
Who am I debating today, Steve?
Oh, yeah. So I know a lot of people want to know, and we'll just get it out of the way real quick because they haven't heard your assessment of what happened, what you thought of the whole debate with Jingris. After everything that happened, I'm sure you read a lot of the comments. You probably got some feedback as well. What was your take on the whole debate with David?
Yeah, I mean, he was how he presents himself in his tweets and everything. I know that you've had conversations with him where he's been a little bit more of a reasonable guy, I guess, but he was rude. He was defensive. I thought he was a poor debater. And I know a lot of people would wish that I would have yelled at him more or interrupted him more. But as lawyers, that's not really the way that we're supposed to argue. We're supposed to wait until they finish saying the stupid thing that they're saying and then take our turn. So I just felt like we kept giving him rope. He kept hanging himself. And I didn't hear anything in the debate to suggest that he was even listening to anything I was saying. And that's okay. I mean, he wasn't going to change my mind, but I also didn't come in saying, well, I invite David Gingras to prove me wrong, and I think if he was earnest in saying, like, I really want to understand where I'm wrong, it would have gone a very different way, because I think I explained just as all of the justices of the Court of Appeals have explained, just as Judge Mata explained, that he's wrong. And his inability to contemplate how anybody could disagree with him is stunning, really.
It really is, because I think one of his biggest things. Okay, we had to pause there real quick, but I'm back. But what I was saying was, what's interesting about Jingris, and I was talking about this with other people, was his biggest thing with the JFC crew is, well, they just have their own narrative in their head, and they're not willing to listen to anything. So why do I even say anything? Because they're just, if it doesn't line up with what they think is what happened, then it's not true. The ironic thing is that's exactly the way he was in this debate. Like, you would question him on cases that he brought up, things that he said, and it's like, well, that doesn't fit his narrative, so he just moves on. It's just ironic how much he hates the JFC crew for having their own narrative when he has his own narrative in his head about everything about this case. And if what you say doesn't line up with what he thinks, then you're dismissed.
And I invited him a couple of times. I said, I'm surprised he didn't come prepared to talk about the cases, because I thought that was kind of the whole point of what we were doing. But I invited him, if I'm missing something, you can go back, you can bring me the quote, you can go back, find a case, send it to me. And he said, I'm going to do that. I don't think it'll surprise anyone that I never heard from him.
The other thing is, I think, and I told you this after the fact, I was shocked, and maybe I shouldn't have been. I really don't think that Jingris thought you were going to come prepared. Like, the fact that you had your notes, you had your highlighters, you had Rule 26 written out on paper. I for whatever reason, I think this guy just thought you were just going to wing it off the top of your head, or maybe he didn't think that you were as well versed in this case than he had hoped or had thought. I don't know, but he was very ill prepared.
He certainly didn't expect me to have read the cases and have quotes from them. I mean, that's what you're supposed to do when you're a lawyer and you cite cases. You're supposed to read them to make sure that they say what you think they say. You're supposed to understand them factually and legally. But, he had block quotes that didn't say what he said they said. And I read the cases. It wasn't even like I, scorched the earth on this legal research. I just read the cases he cited. It wasn't that hard.
And the funny thing about all of it is, we bring you on because I knew you would be able to talk to him in the legal speak going back and forth. And I think one thing that's funny is, through all of this, it's not like I brought somebody on that is kind of well-versed or had read some things here and there, or somebody that wasn't even a lawyer. And the fact that your arguments line up with Mata and 3 appellate judges. Like, it's not, I'm trying to explain, like, David, you're acting like I just brought some random person on just to debate you. It's somebody that has presented you with arguments that another judge, Judge Mata, did, and 3 appellate judges did. Like, you've lost everywhere. How are you not accepting this? And I kind of want to almost ask him now. It's almost like he's a cult leader and he has a faction of
2.
one. Yeah. So him and Laura. He's got one person underneath him, because I'm just trying to rack my brain of, what is he presenting to Laura every time they lose that she's like, yeah, you know what? Let's do that. Let's keep going, because every single step along this way, he's lost. How do you present this to a client?
Well, if she's not paying fees, there's not a ton of incentive for him to stop, because it's not really costing her anything, and she really has only upside. But and this is just where he really loses credibility. I mean, if he actually came out and said, I completely understand your argument and I see that point of view, but I disagree, and here's why, that would be one thing. But you lose all credibility when you say that the arguments that the trial judge and 3 appellate justices, who he himself said would never get this wrong because of how smart they are, when they all said, not only were you wrong, but your argument was so wrong, we're awarding appellate fees. Okay? To pretend as if that argument that all of us agree, and all of the other people who've talked about this case, Omar and Lauren, we all have the same analysis. Some lawyers, some not, but the lawyers all have the same analysis. How can he say that it's just absolutely batshit crazy when he's the only one standing out on normal land? Because I haven't heard anybody who agrees with anything he says, except for the 1 or 2 things I've conceded, and I'm the only one has conceded that he says that aren't entirely wrong. They don't change the outcome, but
The other thing about the appellate judges that I find funny is, before they came down with their ruling, remember, he was like, I'm so glad the appellate judges are outside of Scottsdale. They're in Tucson. They're not like Mata, who is so caught up in the Bachelor world and her sister follows Clayton. These are going to be 3 independent judges who aren't caught up in the whole Hollywood bullshit of it all. And then they ruled against him, and he's like, they don't know anything.
Yeah, and I'm sure we're going to hear in some brief that they're all, they all follow The Bachelor too, and they're all, all their moms and dads are in their chambers when they write articles. I mean, it's so over the top that I don't really think, I'm not even sure he even believes what he's saying, because it's so ridiculous. But I don't know. I'm not going there.
Yeah, I think the thing that bothered me obviously the most about the debate was, his long answers. Like you said, as lawyers, we wait for them to give their answer and then we retort. The problem is, in his answers, he could go on for 10 to 15 minutes straight, and you just never got that chance. And even if you wanted to start giving a long answer, he was never going to let you finish any long answer, because he would step in the second he heard something in your answer that he wanted to dispute. He would never let you finish an answer.
Or interrupting me when I make a face. And I said, wait a minute, you haven't let me get a sentence out. And when I make a face, you're all indignant, and after, I mean, it was too much. It was
exhausting, to say the least. But the other thing that bothered me was, every time he said, with all due respect, Rachel, and then he would the very next sentence would go on to disrespect what you had just said. It's like, that completely eliminates you saying with all due respect, because you're almost literally setting yourself up for, I'm about to disrespect you when you say that.
Yeah, it's like when people start out by saying, I'm being completely honest here, blank. Like, that's when you're about to hear a lie, right? Whenever you hear something that starts with all due respect, it means they have no respect. But, look, I wasn't expecting much more from him. So, it was what it was. I was frankly surprised that he wasn't more prepared, and wasn't ready to debate the cases and the wording of the statute, but that's okay.
Yeah. It's fine. And so ever since then, the big news to come out of that debate was he used that debate as his reasoning for filing for reconsideration. And for those that don't know, he took to his Twitter and he said, he said to me in an email the night before and called you batshit. And he goes, that's why I'm going to file for reconsideration, because after going over that debate with Rachel and realizing she was batshit, made me realize I need to file for reconsideration. Something that when he lost the appeal, the first thing he said on his blog was, reconsideration barely ever works. I highly doubt we're ever going to go this route, but we're not done. We're definitely going to go to Arizona Supreme Court. But he was so poo-pooing reconsideration until this debate. Now, to the layperson, fill everybody in on what he did. What does it mean, him filing a reconsideration? Does this mean, hey, 3 appellate judges who ruled against me, you missed this, or you're completely wrong? What is reconsideration? What do the appellate judges do? I think not Jingris. Woodnick has till the 5th to respond. What do you think they're going to say in the response? Just kind of fill people in on what happens from here.
Yeah, so this is similar to the appeal in that, I mean, Woodnick's firm obviously has done a wonderful job. I'm sure I will be even more educated to speak about it when I see their response to the reconsideration, but I've read the brief, we've done the research again. And I have a very different theory about why he filed for reconsideration. It's not just because he thinks I'm batshit, but it's because he realized as a result of our debate that what I think is his best argument, which is the causal connection between the fees incurred and the unreasonable behavior leading up to seeking the fees, might not merit all the fees that were incurred. He realized he hadn't raised that on appeal. And when I said, show me where you've raised that argument, he said, oh, it's in there. I'll find it for you. It's not in there. He did not adequately brief that issue. And I think he realized that. And I think he realized that his strongest argument here is probably to attack the amount of the fee award, or to attack, the sort of reasonableness of the amount of fees awarded, because it does seem like a lot when there weren't many fees incurred until the fee trial, which doesn't mean fees are not appropriate. But I think that's an argument that might have had some traction. And when he realized he didn't raise it, I think that I kind of turned him on to that argument. So I begrudgingly take responsibility for this. But I don't think this is likely to succeed. And the reason is, as he said, and the Arizona court's website itself says that a motion for reconsideration that just re-argues the same arguments or raises new arguments is very unlikely to succeed. That's straight from the judicial website in the state of Arizona. Typically, motions for reconsideration, very unusual, very unlikely to succeed in general. They're really supposed to be to address a specific issue, right? There was a case that was overturned. The law has changed in the time since this decision was handed down. Something really odd, right? Or some real just complete error in law from the Court of Appeals that isn't just a simple disagreement, right? They made a fundamental error of law that needs to be relooked at. And you don't really have that here. What you have is a very small thing that he quibbles with, which he raised extensively in our debate, which is this discussion of the structural error issue. But then the majority of the rest of the brief is discussing these arguments, which even the non-lawyers here will realize are not arguments that he ever raised on appeal, because he starts getting into the details about parenting time and why there shouldn't have been an award of fees based on any parenting time statutes, why there shouldn't have been an award of fees based on discovery statutes, and just that the court's decision did not adequately support its finding of liability under those statutes. And that's not an issue that he raised on appeal. So that doesn't mean that the court cannot consider this new argument on reconsideration, but that's really not what reconsideration is supposed to be for. And I don't see the court, who gave him the full chance to brief these issues and found his arguments to be so simple and so lacking in merit, I don't see this as the type of, very nuanced legal issue that a court of appeals is likely to say, you know what, this was a very complex legal issue. And we do see kind of how something might have gotten, kind of turned around here. These are very straightforward issues, not the type that you usually would see for reconsideration.
Does him filing for reconsideration affect him as a lawyer? Like, maybe not his credibility, but some people have emailed me saying he's going to lose his license over maybe not this, but just kind of everything that he's done. Does this hurt him as a lawyer if you file reconsideration?
I wouldn't say so. It's certainly not a good look. And, I think at some point, everything that he's done in this case is really, I think, grounds for the bar to take a look at him. And certainly filing a motion for reconsideration without merit is not going to help the situation. But it would be really improper for someone to say, well, you filed a meritless motion for reconsideration, we're going to yank your bar license, right? That would really be very chilling to lawyers. I wouldn't even want to see that happen. It's all the other stuff. It's the personal insults at Judge Mata. It's the attacks he's made on the witnesses, calling the police, on Mike, and the things he said online to people that are, just engaging with him on the legal issues he's put out there. That's the kind of stuff that the bar should look at, not whether he had a basis for filing a motion for reconsideration.
So let's bring up some of the things that you wanted to look at in his reconsideration. Yeah. Bring up page 6 first here. And do you want me to scroll down, or where do you want me to start with page 6? These two.
Can we pause for 1 second? Just pause for 1 second. Is that okay?
Yeah. All right, we're back. Just had to get the knock at your door answered. All right, so we're bringing up the page 6 of the reconsideration motion that he filed here.
Right.
So explain this.
Yeah, so this is after the discussion that he has about the structural error misstating Arizona law, which he and I argued about that extensively. And that to me is we disagree on the legal analysis. It's not a clear error of law that's going to be reversed. This is where kind of anyone who's been following this case and the people that have been listening are going to see and are going to start to hear arguments that they say, wait, I haven't really heard those before in any of the appellate briefing. And he starts out basically, reversal is mandatory because the trial court failed to make the required statutory findings to support the awards of fees. There is some allusion to this concept in his appellate briefing, but it is not a argument that he really put forward. He didn't discuss the specifics of it. He really focused, which again was his error. It was his strategic and legal error. He really focused on Rule 26. And the problem is, even as he goes through this analysis, he starts to fall back into this concept of the fees were really awarded under Rule 26. That argument is gone. He's lost that argument. The Court of Appeals was very clear. He has absolutely no basis to argue that kind of judgment call that the Court of Appeals made, that yes, this was clearly not a Rule 26 award, and therefore 90% of his argument doesn't mean anything. That's not something he can really recover from. So his only real alternative was to start raising arguments that he hadn't raised before. And so here he goes into why there was no basis for the fee award. And you see things, obviously, which we haven't seen in the appellate briefs before. Clips from the petition and the response, talking about parenting time. If you go on to the next page I had.
9.
Yeah, which is page 9.
Yeah.
Right?
Yeah.
And this is where he kind of can't help himself from saying that the discussion of, Rule 26 was irrelevant and unnecessary. He kind of goes back to the argument that this aspect of the court's decision was incorrect as a matter of law for other reasons, right? And this issue was fully briefed. He really is just regurgitating the same arguments, except he's kind of trying to shoehorn in this concept of the fee award wasn't appropriate under these other statutes anyway. And that's basically what his, lengthy argument. And if you notice the Kent case there, he's citing an unpublished case.
Kent versus Kent here?
Yes, he has the Westlaw citation, which suggests that, it hasn't been published or unpublished yet. It's a recent case. It's from February of 2025.
Yeah.
But this is a case which could be published. And the issue here is that in that case, the argument on appeal was on appeal, right? This was a case where they said on appeal, the trial court did not make the adequate findings to sustain an award of fees. I'm pretty sure he could have found cases that were not new that said that. That shouldn't be a surprise to anyone, that if you appeal a decision on the basis that the findings were not legally adequate to support the determination or factually sufficient to determine to reach the determination, that the appellate court should reverse it. That's not a surprise to anybody. What he really hasn't done here is gone into the propriety of now raising new issues in a motion for reconsideration. And I suspect that in addition to, to addressing these arguments, that's something that, Marcus or Woodnick's firm will focus on in their reply or their opposition to this, is that this is really, $1 short, a day late, $1 short.
Now on page 12.
Yeah.
What did you want to discuss in this page?
Right. So this is where he says he raised the issue before the trial court, right? And this is where he goes into the fees being necessary.
Yeah.
Right. And what he still doesn't do is explain why he didn't raise this issue on appeal. And it's, that doesn't, again, completely preclude review on reconsideration, but a motion for reconsideration is not supposed to be your chance to fix what you didn't do in your appellate brief.
Your own
mistake. He had a fair shake. Yeah. And it really he was driven so much by this obsession with Rule 26 and this cockamamie argument that Rule 26 provides a safe harbor against any fees, any sanctions under any statute, that he devoted his entire argument to that instead of trying to look beyond that and, see what his other bases for appeal would be. It also, this is the kind of argument that is also generally harder to make on appeal, because it goes more, it's less of a strict legal error than it is discretionary, and, whether or not the court adequately, supported its conclusions is a lot harder of an argument to win on appeal. So I'm not entirely surprised that he didn't make it, but I think this is when he realized maybe that was his best argument after all.
Okay.
And then we go to, I think, 14,
yeah.
right? Right. And this is just another good example.
Time build.
So this is another good example for people who have been following the case. This is not an argument that we have ever seen cogently, put forward by him, going through the specific time entries and saying this time entry was not a reasonable fee. This time entry was not causally related to the misconduct. That was just something he never adequately briefed before the appellate court, and frankly doesn't really specifically address it either in this particular brief, right? Even this motion for reconsideration, right? You have the time billed consulting entertainment lawyers. That can sound kind of like, oh my goodness, that's really not related here. And a court could find that it's not related. But the trial court has tremendous discretion. And this is where he kept getting hung up on, in a lot of the arguments that I had with him. There are some things like whether or not these fees were appropriate that could go either way. But the judge gets to decide that when they get to go either way. She was fully within her right to make a determination as to which fees were reasonable. And frankly, his client is the one that made this contact happen. Clayton did not run to the press and say, press, let me tell you all about what's happening, right? I mean, it was Laura who came forward first. Obviously the pendulum has now swung the other way, but you have the same thing with the Rule 26 issues, right? They're saying that, the Rule 26 fees should not be awarded. I don't necessarily disagree that if I were making the determination in the trial court, that I might have said, you don't get your time for Rule 26 stuff because your Rule 26 motion had to be withdrawn. But first of all, you're talking about a total of 5 hours, right? That he's pointed to. Very small amount of fees compared to the whole. And this goes to was the fee award $3,000 too much? Not, was this entire fee award so egregiously improper that it has to be vacated and reversed and Laura given her fees on appeal for this horribly biased decision that was made, right? This is more of nitpicking at the fees. And frankly, that's something that if he wanted to do, should have been done initially. but probably would have failed initially because this is where the court's discretion becomes so relevant.
So it just looks like these are the ones that he brought up. Just looking at this page, $88, $50, $59, $130, $85, $88, $59, $170, $177, $1,500, $260. He's basically saying none of these are relevant to the case. Take them out. Well, even if you do, that's $2,000 roughly taken out of this case. It's still $148,000 of fees. Like,
yes, exactly. Yeah, I gave him too much credit when I said 5,000. You're right. Your math is much better than mine. It's like 2,000, Steve.
It's like 2,000 on this page. Yeah.
And that's, look, that's the type of thing where if that argument was raised this specifically at the trial court level and I was the trial court judge, I actually might have agreed with him that, time they spent on the Rule 26 motion should not have been awarded. I might have agreed. I might not have, but I don't think that's such a crazy argument. But it is totally too late to be raising it. And it's really not going to change the results here because $148,000 in fees versus $150,000 in fees. Even if the appellate court at this point agrees with him, it goes back to MATA to recalculate the fees. It doesn't throw the whole fee award out the door and have it reversed. Yeah. Right. So now he's kind of just grasping at straws for what can he salvage out of this.
Doesn't seem like much based on what you have said. I mean, at this point, you just think, so Woodnick has till May 5th, I believe, to respond to this. And then Jingris gets to come back again and do his probably within a couple of weeks, I would assume. Right. And then how long before we get a judgment on this reconsideration, whether or not they're going to consider it?
I mean, probably not a hugely long time, but there's also no guarantee that it's going to be quick. If this is something they asked for an opposition, they asked for a response. Because I don't practice in Arizona, I don't know how common it is to ask for a response, but I do know that statutorily, they cannot grant a motion for reconsideration without asking for an opposition. So if they're even going to take a look at it, right, they have to ask for a response. They really do. And my guess would be that, people file motions for reconsideration all the time. Pro pers file them all the time. And because there's no absolute right to do that and to have it considered, that anytime they get something that isn't like written in crayon, right, they might as well ask for the opposition so that the both sides are briefed for them, rather than reading one side, trying to decide whether they want to consider it. Anything that seems halfway coherent, which I guess is a compliment from me to Jingris, that this is, written in English and coherent.
Not crayon.
Right. Yeah, it's not in crayon. It's not on a napkin. It's not a pro per filing a motion for reconsideration on the basis that the judge is an alien, which, is going to merit the court looking at it. But I don't know that because I don't practice appellate law in Arizona.
But we know, has lost every single motion he has filed in this case.
Yeah.
He even said at the beginning, before he filed the reconsideration, very rarely can you win this, 1 out of 10 or whatever he said, 1 out of 100. But once they did grant him and didn't immediately dismiss this, he's now using it. He said it specifically on his Twitter, like, this is good for Laura because they could have dismissed this, but now they're asking for Woodnick to respond. Is that anything?
He's not wrong that it's not bad. There could have been a worse outcome where they just rubber stamped it no. Yeah. Right. The how good it is really anybody's guess. If you'll remember, he said the same thing about the bar complaint issue, right? Oh, look at all these other bar complaints that have been dismissed out of hand. And Mata's is still out there. My complaint against Mata. I remember at some point he went through a calendar of all the bar complaints that were filed before his that had already been dismissed. And that meant they were taking a good look. No, those bar complaints were probably written in crayon by a pro per who was complaining that a judge saw an alien and ruled against them. His was written from an attorney, which immediately gives it more credibility than a lot of filings that the courts see. And, it's in English and it can be read and it has cases cited. So, it's very possible, just like his bar complaint with, against Judge Mata was dismissed very quickly once it was reviewed. The fact that they didn't dismiss it out of hand, as a lawyer, I wouldn't see that as such a huge victory that they didn't dismiss my arguments without even reading an opposition.
As my dog barks in the background. I don't even know what she's barking at. But so we really do think at this point, reconsideration after Woodnick responds and then Jingris responds to that. He's probably not going to win reconsideration. And then we know he's going to go to the Arizona Supreme Court. We're going to have to do that. We're going to have to go through that song and dance. You don't think he's going to win that. And then he says he's going to take it up with the United States Supreme Court.
Yeah.
Another thing
good luck.
Think he's going to win. Yeah.
No. The United States Supreme Courts deal with constitutional issues. They do not deal with the proper application of state statutes. Okay. Now, if there's an issue with a state statute conflicting with a federal statute, if there's an issue of due process involved in some state statute, due process being a constitutional issue, they will look at state statutes and they take cases from state Supreme Courts, not just federal courts. But the Supreme Court of the United States is not spending its time saying, oh yeah, you're right, David. Clayton for 2 hours speaking to an entertainment lawyer. And that just was not appropriate. And so we're going to cut that $400 out of Judge Mata's award. That is not what I hope everybody's glad to hear. That's not what our Supreme Court is doing, right? It's dealing with much bigger issues. And I don't necessarily always mean bigger cases, because sometimes, a misdemeanor criminal case can raise an important procedural issue of due process that goes to the Supreme Court. So it's not that it has to be $1 billion issue. It's just the Supreme Court is not spending time reviewing decisions of state trial courts to see if they're right or not. They're dealing with much bigger picture issues.
And one last thing before we get to the questions from listeners. Yeah. You probably saw him tweet out comparing this case or what Laura is dealing with to the Kilmar Abrego Garcia case, the U.S. citizen, or actually, I shouldn't even say U.S. I don't even know. I just know that the person who was living in Chicago, I think, that got deported to Excalibur. I got Vegas on the brain. El Salvador.
Without any due process.
Yeah.
Right. And that's why, cases like that, where somebody is deported without any of the required due process in the courts, one guy's deportation can be a Supreme Court case because the issue of due process is such a core constitutional issue. But Laura was not denied due process. Laura had lots of process. She had hundreds of thousands of dollars of process. Now, you can still have a due process violation in a case where a lot of time is spent. But to even compare the two is, that's shameful, is really the only way I can put it.
All right. I asked some listeners to send in some questions. I'm just going to read them to you. Yeah. There's probably about, 10 to 15 here.
Oh, wow.
And
okay.
Some of them are legal. I actually think this first one, just kind of looking at it before, I think it's what we just went over. This is from James. And he said, I heard on a visit years ago that Supreme Court gets a lot of requests to review cases and only takes a tiny fraction that I at least think 4 justices have to agree to even review the case. So when Jingris loses in Arizona, what's the chance he'll even get the Supreme Court to hear it? And will the state court even have to review it either?
Yeah, there's a far more complex process in the Supreme Court of the United States than most people realize, and I think even than most lawyers realize, because most of us don't practice in the Supreme Court of the United States, where each justice is assigned a territory of the country, and their clerks, who are top students from the law schools across the country, the smartest minds in the country, become Supreme Court clerks, and every Supreme Court justice pretty much has been a Supreme Court clerk. These are the big intellectual minds of our generation. They are responsible for reviewing petitions all the time. And then they recommend, and then the justices sometimes vote on whether to hear it or not hear it. There's a whole process behind the scenes of whether to hear the case. There's no automatic appeal of right from a state court to the Supreme Court. So they have to decide that they want to review it because it presents an appropriate issue for review, a compelling issue for review. And they have to determine they have jurisdiction to decide the issue. I couldn't give you statistics, but it's a tiny fraction of cases. If you appeal your case to the Supreme Court, there's absolutely no guarantee that they have to hear your case or decide your case. They can simply say, we decline to review. Thank you very much. Goodbye.
And
I'm sure that is what will happen in this case, because this does not present any constitutional questions, any questions of the intersection between federal and state law, any issues of sovereignty. It doesn't invoke any of the issues that the Supreme Court deals with. This is like whether or not a trial court in Arizona correctly applied Arizona law. That's really all it is. And the Supreme Court does not care, I hate to say it, about that.
April sends this in. She said, I appreciate your non-legal look at this case because, like you, I don't understand all the legal stuff. With that said, I want to dumb it down even more because I don't understand if the whole point of the case is to prove that Laura lied and was dishonest on the stand. Why aren't the bigger things being pointed out, specifically that she was no longer pregnant? And the fact that, considering how far along she supposedly was in her pregnancy, knowing that she couldn't have miscarried but still rather have a stillbirth. If you're trying to prove she was never pregnant, why wouldn't that proof need to be proven or disproven, since a stillbirth would have resulted in a hospital stay and or a death certificate?
Right. So I think I understand the question. I think the question is, why on appeal were we not focused on proving whether or not she was pregnant in the first place? And the answer to that is basically because of the fact that Judge Mata believed that she filed the petition without good cause and believed that she did not establish that she had good cause to file a petition because Judge Mata didn't believe she was pregnant, right? Judge Mata didn't believe
that Laura didn't believe that Laura was pregnant.
Right. Judge Mata, I think felt that even Laura didn't believe she was pregnant or didn't have a good faith basis to believe she was pregnant if she really did, without doing any of the things that she did and with all her falsifying the sonograms and stuff. Those conclusions of credibility of what Laura believed are almost impossible for an appellate court to change, because decisions of credibility and weighing evidence are left to the trial court. Because no matter how good or long or well the appeal is done, the appellate justices were not sitting in trial, and they know that. So they're not there to say, gee, Judge Mata, I watched the trial on YouTube. They don't even do that. They get the transcript, right? But I've read the transcript, and I think Laura was a little more believable than Clayton. I actually do think that urine stick test probably was accurate, whatever. Those are the sort of judgment calls that appellate courts don't touch, because the trial court is in the best position to do that. So on appeal, the issue really wasn't, was she actually pregnant or not? It was the fee award legally appropriate, right? And all of the sort of underlying determinations, proving or disproving one of them really isn't the issue. They kind of have to adopt what the trial court found and assume that there was evidence to support what the trial court found, unless it's just obvious that there wasn't, right?
So Beth asks, she's got a few questions here. So the first question that Beth asks is, it seems like the investigation of Laura Owens by Rachel Mitchell, county attorney, is taking a long time. Is this typical? Almost a year since she was referred by Judge Mata for investigation.
I don't think it's atypical, right? I think that, the most surprising thing that came out of the debate was when David said that they were actively issuing subpoenas in Arizona, and he was aware of that. I don't know whether he misspoke, but it didn't seem like
a lot of people seem to think he did.
Yeah. And if that's the case, right. And if that's the case, and they really are actively issuing subpoenas, not only is this kind of a investigation that is, taking a while, but they're actively pursuing it, right? These things take a long time. This is not going to be top of Rachel Mitchell's, priority list, even though she's getting some pressure to do it. But it sounds like from what he said, that's the best indication we've had so far that it's actually being pursued. Otherwise, I wouldn't be sure what was happening.
Second question she had was, what are your thoughts regarding prosecuting perjury? Laura Owens swore to tell the truth and then admitted that she had lied while under oath. Laura said her lie was just a minor thing, quote unquote. If she is allowed to lie under oath with zero consequences, why ask witnesses to take an oath in the first place?
I mean, that's a really great question. And it's the fact of the matter is that perjury is just not prosecuted. It just isn't, particularly as a standalone offense. And there's a good reason for that. I mean, it's a resource issue, right? It's just like the fact that, jaywalking is against the law. They're not prosecuting jaywalkers most places, right? It's still important, I think, to give an oath to tell the truth. I think it's still a lot of people, not all, but a lot of people take that oath seriously. And it does give added credibility to their testimony. But it also gives rise to a lot of other legal conclusions, not just the possibility of prosecution, but there are all sorts of legal concepts, right, that finders of fact, what juries or judges apply, such as if somebody lies under oath about one thing, you have the power to reject everything they say on the basis that you believe them to be a liar. So, if they didn't take the oath, you kind of lose a little bit of that, right? So, I understand it's kind of toothless in the sense that people aren't prosecuted for it, but lying under oath can have a lot of consequences for your case, even if you're not criminally prosecuted.
The next thing she asked was, are you aware of any attorneys who have done some of the same things as Jingris who have been disciplined or disbarred?
No, not aware either way.
And then the last one was, do you feel disrespected by Jingris during your debate, especially when he offered you a cookie?
So I didn't even remember that happening. I saw someone refer to that. Absolutely.
I remember him saying, and he literally had a cookie at his desk, and he said, "What do you want, a cookie?" And I was just like, "Oh my!"
I don't even remember that. I think I had so tuned him out by that point. No, yes, absolutely. I felt disrespected. I'm also very used to it. I think, both just from being a young female lawyer, but also, anybody who watches Hot Bench can see a lot of our litigants don't have much respect for our judicial court. If you kind of take that stuff personally, it was definitely disrespectful, but I didn't take it personally. It didn't upset me, because it's just kind of like, if I took those things personally, I'd be, under a rock somewhere crying about all the, comments online about what a terrible human I am.
Yeah, your mental health would be in the dumpster.
Oh, yeah.
You take everything personally like that. Pam asked, in order to appeal a case to the U.S. Supreme Court, there has to be what is called a federal question. Otherwise, they have no jurisdiction. What does Rachel see as the federal question at issue in Clayton's case? It seems to me it's about Arizona state law, and that's it.
Right. I mean, that is correct. And federal question jurisdiction is not the only type of jurisdiction. It would be the one that would have to be here, because none of the other bases for jurisdiction could even really conceivably exist. But this one doesn't either. The only, and I don't even want to say possible, because I really don't believe it's invoked, but the only potential constitutional issue, which is a federal question, is this issue of whether or not structural error applies in family law cases and civil cases. And if so, the standard of review. But I don't even really believe that question is squarely raised by this appeal, because the issue here is not that the Court of Appeals said structural error does not apply. Otherwise we would have had it, but it just doesn't apply in this case, or it doesn't apply in family law cases. They said that the structural error, it wasn't structural error, right? And I completely agree with that, based on the cases that David Gingras cited. Talk about not any time a judge does extrajudicial research, it is structural error, but rather in a more limited context, anytime a judge does not properly disqualify themselves for bias, that's an example of structural error. And I kept pointing out to David Gingras that was what his own case said, that the structural error in that case was not that extrajudicial research was done, period. It was the judge didn't disqualify themselves, and therefore a biased judge presided over the entire proceeding. And that question just really wasn't before the court, whether or not structural error could apply in civil and family cases.
This next one asked, David Gingras had an April 18th deadline for filing a response to Clayton's costs and fees. Nothing has been filed as far as I can tell. You think he really let that go, or did he get so wrapped up in his reconsideration that he let the deadline pass? I can't imagine him not filing a response, since he's never been one to just shut up and let anything go.
Yeah, that's a really interesting question. I was also wondering, there's another deadline coming up, for seeking certification to the state Supreme Court. I don't know in Arizona, and this is something I could look into and send you an email about, or perhaps, the Woodnick brief will address it. I don't know if any of those deadlines are stayed or told if there's a motion for reconsideration pending. It's very possible they would be, because if you're going to reconsider the whole thing. It's not necessary to do that filing. But I just don't know, because oftentimes other deadlines would not be told just because there's a possibility of something happening, because it would slow everything down. So who knows?
Yolande asks, I don't know how to word this, so feel free to word this as you feel appropriate. I guess that's to me. Can Rachel give an idea if Clayton can breathe easy, relax, not stress about this situation now, or does he have to wait until the lawyer takes it all the way up to the Supreme Courts before he can put this behind him? Or is there some range of this that is mostly behind him? Basically, if you're in Clayton's shoes right now, how do you feel about everything?
Well, I feel not good that I'm still incurring attorney's fees because, so in that sense, this is not behind him until Laura stops what she's doing, right? Until David Gingras stops giving her free legal services, because Clayton's attorneys are not working for free, nor do I think they should. And yes, they can seek a lot of these fees from Laura, but they have to collect them in order to get them from Laura. And we've already seen the groundwork laid that, like, she's broke and she's judgment proof. And in those type of circumstances, typically, I don't know Clayton's arrangement with his lawyers, nor would I ever ask. That's between the two of them. But typically you collect from your client first, because the lawyer's entitled to get paid even if the other side can't pay the judgment that they're supposed to pay you. So my guess is Clayton is having to fund a lot of this out of pocket, even though Laura has been ordered to pay the fees. So it's not really behind him until everything is done. In terms of what are his when can he kind of like breathe easy that he's not going to lose this case? I mean, to me, even if he loses this case at this point, the only thing he loses is a fee award from Laura. So it's not like the end of the world, it's money that he's going to spend the rest of his life trying to get from her, right? I would say that like the really bad outcomes, I don't think he's going to lose his fee award. But if I would not expect him to be like up at night worrying about this case anymore, because at this point it's basically, does he get reimbursed for these fees in 7 years when he can go, finally collect from Laura, or does he not? That's really all that's at stake. In terms of like, when is it 100 or 99% certain he's won? I would say we're not there yet. I would say after the Arizona Supreme Court declines to review it, I would put it at 99.9%, because there's no way the Supreme Court of the United States is taking this case. That's the only thing I've ever said legally. There's no way. And there's no way that's happening.
Kristen says she would like your perspective on how you feel about him, David Gingras, having no interest in knowing or understanding anything that predates his hiring. He has made it clear he hasn't gone back and read anything that happened prior to him taking the case. We know that multiple lawyers quit before he was hired. We know that many things happened prior to Clayton with the other men who were lied to. He seems to have no issue with calling these previous men liars, but it's also clear he doesn't know anything about these cases. I get that legal representation isn't predicated on believing your client is innocent, and that due process requires legal representation regardless. However, I just find this perspective very odd. Anyway, just wanted your opinion on that and how you would handle the situation if you were hired midway through the proceedings. Would you go back and review all previous cases and filings, or would you process similarly to how Jingris is going?
No, I would go back and review all the ones that were in any way relevant to what I was doing. And for him to just assume that, the court, this is such an easy legal dismissal that I don't need to know any of the bases that they're asking for fees on, I think is ridiculous. But I agree with that person that asked that question. There's a big difference, if you compare this to a criminal case, there's a big difference between representing a criminal defendant who you don't believe is innocent and going before the press and calling the police officers and the prosecution liars who planted evidence and should be fired, right? You can adequately and zealously represent your client in court without doing things like were mentioned, like calling Mike Maricini an abuser, like insisting that the cops should have been called on him because this was an abusive thing he was doing to Laura, and saying that all these men are liars and they're all losers and liars who have all abused Laura in the past. And to go after Clayton like that as well, that just takes it much farther. And I think that's totally inappropriate. Which is why I've always said I don't fault him for representing her, but the fact that he has so staunchly stood behind her and gone on the aggressive against other people, while at the same time saying, I don't want to know if she's a liar. I don't want to know if she has, deceived men before. I don't know about that. I don't want to see those text messages because they might not be real. Okay, if you don't want to do that, fine, but then don't jump into the fray on whether Mike Maricini is a good guy, on whether, Gillespie is, a good person or a bad person, on whether they're abusive, right? If you don't know the facts, you stay out of that.
You can't speak on it so confidently like he has.
Right.
Which is just, yeah, it is a head scratcher when it comes to him. Only a couple questions left here. Yeah. Catherine has a few, but Catherine says, what, if any, significance is there for the appeals court asking for a Clayton response? I think we went over this. Does this mean they could overturn the original appeal decision? What would be your strategy for Clayton's team here?
I mean, the first thing I would do is, particularly because Jingris doesn't address it, is I would really heavily brief the issue of this just not being appropriate for reconsideration. Even if he's right, this is, appellate review has standards. And it is not simply that the trial court made a mistake. Because if every time the trial court made a mistake, you won your whole appeal, we'd be in this like endless cycle of litigation that would never end. Yeah. So that's where I would start if I were them, trying to just prove that this is improper for reconsideration, because I think that's probably a winner.
What is your response to Jingris calling you names and blaming you for submitting his reconsideration?
I mean, if I am really responsible for the reconsideration, I apologize to everybody. But I think if
as you
I
said
am
at the beginning, you really think that?
Yeah, I think it's because I made him kind of finally realize that his best argument is when he hasn't really argued. And I don't quite understand why. That was always my biggest surprise in his briefing, that he spent the whole time talking about Rule 26 when he knew the trial court claimed it didn't award fees under Rule 26. So, I don't know. I don't have Twitter, so I don't, or X, so I don't see anything that he says unless you send it to me.
Catherine has 3 other questions, but I think I can combine all of them because can Laura be prosecuted in Arizona for fraud that she may have committed in California? I'm thinking of the Dr. Yee forged note about her quote unquote real ovarian cancer. Can Laura be prosecuted for impersonating the family lawyer, Uncle Joe? And assuming Laura is Chase J. Jones, can she be prosecuted for her shenanigans with the subpoena?
All of those would form a basis for prosecution. The issue of whether they can be prosecuted in Arizona, I would assume so, because even though the doctor may be in California, the criminal action, I think, for all of those, and I'm pretty good on the facts now, but I'm not perfect. I know there are a lot of you out there that know them better than I do, but I'm pretty sure she was in Arizona when she created the falsified documents. She had the intention of perpetrating a fraud on an Arizona court. So I think there's more than enough for jurisdiction to lay in Arizona. Whether there's what the specific statutes would be, I don't know, but certainly all of these were falsifying documents with the intent to interfere with a court proceeding. I mean, that's gonna come under a number of different criminal statutes, I would believe. Obstruction of justice, all sorts of things involving evidence. And, I don't know about fraud, but certainly I bet you there are a number of sort of overarching criminal statutes that her conduct would fall under. And I'm pretty sure there's more than a good enough basis for them to be prosecuted in Arizona.
And final one from Julianne. She asked, do you think the bar complaints against Jingris is something that will be taken seriously?
I'm sure it'll be taken seriously. Whether or not it results in disbarment, I mean, I would be surprised if it results in disbarment. I think a lot of his conduct is really improper and really inappropriate for lawyers to engage in, specifically the calling names and fighting with people on social media, and a lot of the stuff he's done to and said to these other men. But at least here in California, the disbarment is kind of reserved for stealing clients' money, disappearing and compromising your client's case so that they lose it because of your lack of diligence. And even then, you're really not automatically disbarred. You're given a warning or a suspension. It's that those penalties are really saved for just absolutely the most egregious conduct. So I think it should be taken seriously, but I would be surprised if he's disbarred over it.
So you're basically saying a lawyer can't get disbarred over just being an asshole, essentially.
Yes, that's basically what I'm saying. Yeah. I think disbarment, I wouldn't be surprised if he received a reprimand, about civility and his conduct and, calling the police, things like that. And particularly, I think one of the most offensive things is what he put in his pleadings about Judge Mata, saying, "Oh, daddy, aren't I an important..." That just crosses every boundary of civility. It's not how lawyers are supposed to behave towards judicial officers. You can make your argument that you believe she was biased, but mocking her in public filings is so inappropriate and so unnecessary.
Could that result in a fine? Like you said, he's not going to lose his license over saying that about Mata, but do you get fined for that or probation?
I think no, it would be like a warning, like a public or private reprimand. And then I think at least here in California, there's a fine in the sense of you have to pay the costs of the bar proceeding and things like that. So there's a financial penalty, even if you're not, even if you haven't disadvantaged anyone financially, like even if you haven't stolen money from a client, you can still be responsible for costs of the proceeding. And, you can be ordered to take ethics classes. My guess is that if he's disciplined, it would stop at a reprimand, maybe something a tad more serious, like a probation period, a suspension, but it's put on hold for a probationary period, something like that. I'd be really shocked if he loses his license or is actually suspended for any significant amount of time.
Go to your room with no dinner, something like that.
Mm-hmm. Yeah.
Is there anything they could say like, "Hey, you're not allowed to post on Twitter anymore"? Like, or 2-week ban. You do not post anything about any case. You're not allowed to express your opinion on Twitter anymore.
No, it's a First Amendment violation. It's prior restraint of speech. You cannot. The circumstances under which you can prevent speech before it has occurred are very limited in our country, and nor do I honestly think that would be appropriate. You can't really stop him from saying anything on Twitter.
Honestly, he just puts his foot in his mouth when he does speak on Twitter. It's almost good for him to do it because it just keeps showing kind of who he is and kind of shows his cards when he does post on his blog or on Twitter or a YouTube.
And look, over the history of this case, the most compelling evidence in Clayton's favor has come from Laura and Jingris speaking when they shouldn't, right? And we would be in a totally different position even if Laura had done what she did and in the courts and everything, but then she just went away in December. We'd be in a very different position.
Yeah, it really would. Like, she just, I like I said earlier, I know you said it had a lot to do with the fact that she's not even paying him, but just the fact that he's able to somehow get in her ear after every single loss and be like, "Yeah, we might have lost 8 in a row, but this 9th time, I think we got something here." Like, and she's just like, "Yeah, do it. Go forward. Reconsideration." It's just
and if he's a guy who really wants to support victims of actual domestic violence, he's barred in California. I can point him to a bunch of people whose life depends on his help, whose custody of their children depends on his help. If this is really what you're trying to do, pick someone worthy of your help, right? As opposed to, ruining all of these lives. And that's the other part of it, is not only is he going after these people, he's helping her attack Dave Neal. He's helping her sue other people. He's helping her go after Redditors, right? If you want to do good, do good. That's kind of, it bothers me.
Yeah, no. And you made that clear to him during the debate. You told him that during the debate. Why not? I can't remember what his answer was. I think at 2 hours in at that point, I was kind of tuned out to everything that he said because he doesn't listen. It's very, very frustrating. It's like, look, it's not like I was surprised by anything that happened in the debate. Like I said, I was glad that so many people obviously sided with you. You got a lot of praise for how you handled him. He got a lot of, "Oh my gosh, I just can't believe," when I watched Omar's video and Omar just, as a fellow lawyer himself, he's just like, "I honestly don't think this guy understands law. Like, I don't know if he graduated at the top of his class." Like,
I totally agree with that. And that's That's what's just
do you think the one of the points that Omar made was, I think he takes some part of a case and only takes like 1/10 of it, and he takes the part that like shines this shiny object in a case that he saw and says he'll hammer that point home, but he doesn't read all the other stuff around it that kind of makes his point moot.
Absolutely agree with that. And I think another thing he does is, we have all these legal research tools like Westlaw and LexisNexis, where there are a lot of summaries of the law, and then they cite cases. A lot of people just copy and paste them. And, you're relying on God knows who, at this point, probably AI, but you're relying on some constantly recycled analysis of what a case says about a case. And it doesn't even stand for what you're saying it stands for, right? Or you find one sentence from the case and you just stick it in your brief instead of actually reading it and making sure it's an appropriate citation and coming up with your own sort of explanation of why this case relates to yours. I suspect he just, he Googles or Westlaw, puts into Westlaw, the particular topic, and then just copies all the cases he sees and puts them in his brief, right? And that's why I think he doesn't actually believe what he's saying. I really do. I think that I think he's so determined to be right here, and he has nowhere further to fall, that it doesn't behoove him at this point to recognize any gray. There have been so many lawyers that have talked about this case who all think it's very clear that he's wrong. And the fact that he maintains that we are all absolutely idiots, crazy, it's, and I'll tell you one last thing. I think one of the most telling things that happened was when, just at the very beginning of when we spoke, and we were talking about, his decision not to cross-examine Clayton. And when I said, it really doesn't set the right tone. And, it doesn't give the judge a chance to get to know your client when you cross-examine her or put words in her mouth. And it doesn't give the judge a chance to dislike Clayton if you forego cross-examination. And he said, well, that's how it might work on a TV show, right? Clearly taking a dig at, the hot bench thing.
A hot bench show that he admitted he's never even watched before. So
right. Well, I guarantee you he has watched it. I just don't think he would ever admit that he watched it. But anyway, I think any trial lawyer would tell you that is an insane statement to make. Judges are humans, right? Obviously in a jury trial, all that matters, but even judges are humans, right? Judges have tons of discretion. If a judge does not like your client, that is really bad. It does not mean that they're automatically going to lose. And we as judges make decisions all the time, that go against the person we like or favor the person we don't like. It doesn't decide the case. But to actually sit there and say for an issue like attorney's fees, where there's so much discretion, that, the judge's like gut reaction to whether these are honest people is like trying to do something for a TV show, is a lawyer that has no idea what he's doing. That was the one glimpse I kind of got, that maybe he really does believe all of the things he's saying, and he just really fundamentally doesn't understand the practice of law.
Yeah, it's fascinating. I'm glad that debate made him file for reconsideration, gives us more content.
I guess, right? I'll be back on May 6th or whatnot, however long it takes a runner to get the brief from the courthouse.
Yeah, we have you on, and then we got to bring you on when he responds to what Woodnick says. And then once the
I don't know if there'll be a
down,
reply. I don't know if there'll be a reply. I couldn't tell from my quick glance at the Arizona rules of court. I'm not so sure he gets another bite at the apple, but we'll see. Well, I'll learn along with all of you, and I'll be back when we see Marcus and Woodnick's firm's brief.
And, I think you're going to have to talk about this probably a lot more. I'm looking forward to you attending my party on May 31st. I know there's a lot of people there that are looking forward to seeing you. Some people that have followed this case very thoroughly and are probably going to, want to talk to you about it. So don't
bring it on. And also for the people that are coming, or for the people that don't know, it's my birthday weekend as well. So we're not celebrating, and it's not that day, but mine is the 29th. So it's like the Thursday. So I think I leave on the 30th. So I'm spending my birthday weekend with you.
Yeah. How about that? That's right. I think you told me that a while back. I totally forgot about that. Wow,
Yeah,
that's right.
I didn't. It's not a landmark birthday for me this year, and I'm not doing anything spectacular on my weekend anyway. So we're just going to celebrate the weekend.
You're attending my party.
I am. That's my big celebration.
Yeah,
so I'm excited, and I'm happy to talk Laura Owens all day long.
Yeah, no, it'll be a good time. Be fun to finally meet you with all the messages that we have.
Which is wild. I know. Yeah,
I know, it's crazy. We haven't met.
I know.
But yeah, that weekend it'll be a lot of fun. We'll play some craps too, as well. Hopefully, Mandalay will have. Did you hear the latest? You probably didn't hear this,
No.
unless you listened to my podcast the last 2 days. So I found out. Kendrick Lamar and SZA.
You told me, because you asked me if I had made that. That they're doing like a concert, right? That same weekend
at Allegiant, which is across the street from Mandalay.
Oh God!
And it's going to be an absolute zoo. And then I found out today, the WNBA team, the Las Vegas Aces, play their games at Mandalay Bay. They play the LA Sparks that night. Kenny Chesney is playing at the Sphere at the Venetian, and Bruno Mars is playing at Dolby Live at Park MGM. So
doesn't that happen like every weekend in Vegas though? I mean, I guess that's a lot of things.
Yeah.
For the same weekend.
There's always concerts going on, but it's the fact that, that's a one night thing for Kendrick Lamar to be at Allegiant Stadium, because I think 2 nights before I think he's in Sacramento or Santa Clara.
Oh, okay.
So it's just a one night thing where he's just on tour, and it just so happens that on May 31st, he's in Vegas across the street. So yeah. Well,
I think I told you I usually stay at the Palazzo in the Venetian, but I was like, I'm going to try Mandalay Bay. So I don't have to go anywhere.
It's a night. I mean, it's the only other place I stay. I stay at Venetian 4 out of every 5 times I go to Vegas.
Yeah, me too.
But the only other place I stay has been Mandalay. I really like Mandalay. It doesn't have the foot traffic as much as Venetian does, but way better pool area. So yeah, we'll be at the pool Friday, and then obviously party Saturday and whatnot. So
yeah, I'll be at the tables Friday. I can't go to Vegas and sit by the pool.
Yeah.
I'm the worst Vegas buddy.
We will be I'll definitely be at the tables Friday night. I'm just trying to determine where, because I'm at Venetian Thursday, Friday, and then come over to
okay.
Sunday. Anyway, Rachel, thanks again for coming on. I really appreciate it. I know you're busy filming season 12 of Hot Bench.
Check your local listings.
Yeah. So when season 12's first episode will air, September, fall?
I think probably right after Labor Day, like first week of September, I think usually. So yeah, we're into season 12. We have our new judge, which has now been announced. So we have so sad we lost Michael, but we have a wonderful new judge, Dan, who's joining the bench. I'm going to be sitting in the middle seat, which is very exciting.
Yeah.
And we have a whole new set, but it's, me and Yodit are back. We have a new bailiff. So it's going to be same old Hot Bench, but a new look and some really fun additions.
How's the travel been on you? As you told people in the past, the travel schedule is you basically film you're in Connecticut for 4 days, then you fly back to California for about a week.
It's like 5, 9, 5, 9, 5, 9.
Okay.
It's been hard. hard. And
how's
what I found is
kids?
My 3-year-old said the other day, but Mommy, you don't live here anymore. And that kind of broke my heart.
Yeah.
But the kids have actually been really good about it. My husband is wonderful with them. We have a nanny, and my kids have been really, really fantastic. It's been hard on me, and mostly it's the time change. It's the fact that I feel like I haven't been on a real schedule ever, because I never really adjust to a correct time. And then when I'm out here, we start filming so early that it's like 3 a.m. in Los Angeles. So there's no way to get on a consistent time schedule.
Yeah, no, understandable.
But I love it, so it's worth it.
Yeah. Anyway, again, Rachel, thank you so much for coming on. Appreciate it.
You got it.
We'll be in touch.
Sounds good.
Bye.